brought by him, and you can clear your doubts if there is any discrepancy in the documents or if there is any correction, etc. So the first, when you cross this, whether it is a literate or illiterate, then you come to certain types of parties. Is the plaintiff or the defendant, as the case may be, a partnership firm, or is it a limited liability partnership firm, or is it a private company, or is it a public limited company, or is he somebody? Suppose you are representing the government, the person who is responsible has come. As far as cases for and against the government are concerned, the Supreme Court said in All India Bar Association case that the government should appoint a person for the purpose of this litigation who should give proper instructions to the advocate without any prejudice. The facts may be sometimes favorable to the
మేడం గారు వచ్చినాయండి 9,000 వచ్చినాయి.
Sir, please note that this program is being recorded and telecast live. Kindly mute your phone voice. So, the particular government official has to give instructions revealing all the documents or other things, other material which he may be having. They may be in support of the citizen or they may be against him. But the Supreme Court said he has to give proper advice. The second thing is, now as you are aware, in NA Act cases, whoever is responsible for the transaction, where the check is dishonored, then the director will be sued. So in a company, you have to verify whether the particular director who is giving instructions to you is having knowledge, because directors will be dealing with several things. One may be a finance director, another may be a director dealing with production and all that. So this is very important. Second thing is, sir, somebody is not wearing a shirt. This program is going live. I think even if you are in your residence, better if you are dressed properly. Then this is the first step. You have to take instructions from the competent person. Now, what is the guarantee that the person will tell you everything that is required to be told? What is the guarantee that he will give you all the documents which are necessary for filing before the court? Or what is the guarantee that he will show you all the documents which are necessary either to be filed or to be perused by you? Therefore, the only manner in which you can ensure proper instructions is to cross-examine your own client. They may not think that this document is important. They may not think that a particular fact is important. Now, where do these facts, they may be immediate facts or they may be facts which occurred a long time ago. If you look at section 7, of the Evidence Act, it says that occasion, cause, or effect. Leading to the occurrence of something or circumstances which have given rise to an incident, whether immediate or otherwise. Therefore, it is not as though the recent facts only are extracted from the client. Sometimes you may have to extract several facts which may be connected and which will be ultimately put forth before the court. There may be 20 years ago, in partition suits, you have to do a lot of questioning with your own client to make out that the property is ancestral or self-acquired. Therefore, cross-examining your own client doesn't mean that you should bombard him with question after question, but you look at the facts and then you clarify. Suppose somebody comes to you with a promissory note, sir, I have lent the amount on promissory note, he has not paid, and I have asked him repeatedly, and he did not pay. You may just put a question. Have you sent email? Or have you sent a notice to some other advocate? Have you gone to his house and asked him? What is the manner in which you have made that demand? That may be important. Sometimes a party comes to you after approaching another advocate and getting a notice issued. Suppose what you draft is not in accordance with the notice issued, then the party will suffer. Even recently here, yesterday I have seen a claim being drafted completely ignorant of the actual transaction that has taken place. The transaction is true, but the manner in which it has occurred was not actually in the pleadings and not actually in the evidence also, but exposed in the cross-examination. Therefore, this is very, very important. We have to elicit all the facts necessary. Suppose it is you want to establish a pathway in a village. Whose evidence is important? You have to ask what material is there? Is there any elderly person who can give evidence about it? So, there are certain provisions in the Evidence Act which require to be within the knowledge of the advocate when you are drafting a pleading in a particular type of case. Now, Section 13A of the Evidence Act Section 32(7) and Section 49, they are all interrelated. (48), 13A, 32(7), 48, you please go through them. Therefore, whenever you are trying to establish a right or custom, what type of evidence is relevant and what type, that means such an evidence may be available. Unless we ask the party, he may not give us the actual evidences available so that you can draft the pleadings accordingly. If we don't ask and if we are not aware of such evidence before drafting, then we will be missing a very important points. Further, when you are drafting a plaint in a partition suit or in any suit where the genealogy is important, you ask the party to write the genealogy. X father, one son second son, daughter, daughter, ex's wife, and all that. So that genealogy should be there in your bundle. If necessary, it should be mentioned in the plaint also. And another thing which is required is sometimes to draft the plaint, you need to know the provisions in a substantive law, say like specific relief act. What is it that you should plead as per the specific relief act whenever you are seeking the relief of specific purpose. Ultimately, the rules of pleadings in the CPC, the relevant substantive law, and whatever provisions are there in the Evidence Act which are relevant for that purpose and which ultimately will become evidence in the suit. All these three things should be in your mind. All these three things should be within your knowledge and draft pleadings. Though I again say that you need not mention the entire evidence. Suppose you are drafting a pleading with regard to adverse possession. What are the ingredients of adverse possession? Against a private person, what is the limitation? Against the government, what is the limitation? It is 12 years against the private person, 30 years against the government. And if you are filing a case under the Land Grabbing Act, what should be the pleadings? What is the definition of land grabbing? And what is the interpretation given for land grabbing? And then what are there in the rules which aid you to prove your case? Therefore, the substantive law is very important. Now, we can broadly divide civil cases into cases arising under the NI Act, Negotiable Instruments Act, say recovery of money on the basis of a promissory note, and then various types of civil suits. And for all these various types of civil suits, you will have the substantive law. Suppose you want an injunction against a defendant who is misusing your trademark, then you should know the relevant law. If it's a case of infringement of copyright, you should know the relevant law, substantive law, before you draft the pleadings. I also caution you that after the amendment of the CPC, it's not so easy to amend the plaint as per our whims and fancies. Therefore, a very comprehensive session with the client is necessary to draft pleadings. And during that course of taking instructions, you should also ask the party to reveal whatever weaknesses there are in this case, whatever disadvantages are there in this case, whatever
books sticker.
infirmities are there in his case, you should try to cover them. And then you should try to cover them. That is something which you learn in two ways. One is to observe your senior while drafting the pleadings, reading them. The other is to read judgments on the on civil side where pleadings are discussed. Say non-traverse. Suppose plaintiff has said something, defendant doesn't refer to them in his written statement. So as far as drafting plaintiff is concerned, what I have said so far is taking instructions from a competent person, which equally applies to written statement. Taking all facts from the party, including those which are not favorable to him. Say a document is there which is not favorable to him. Then the next step is in between taking instructions and pleadings. That step is the necessity of issuing a notice. Because if you want to ask the party to execute a sale deed in accordance with the agreement of sale, you have to issue a notice. You have to decide on the peculiar facts of each case whether issuing of notice is necessary or not. Suppose it's a case of partition. You don't know whether somebody has already obtained a will from the ancestor, whether it is valid or invalid. You have to issue a notice. So depending on the facts, you have to decide whether a notice should precede the filing of a suit. Then the reply comes. And then you will have better opportunity of crafting the pleadings by understanding the reply notice, by understanding the stand of the other party, and accordingly modifying the pleadings. So giving notice to the correct address of the other side, or if he has got email, through email also, preserving the acknowledgements, preserving the postal receipts, and then if you receive a reply, you consider the reply before you actually draft the pleadings. And once again, the next step is to verify the limitation. Now, under the Limitation Act, what is meant by presentation of plaint? Presentation of plaint is to the proper officer having jurisdiction. So, in case you are presenting the plaint on the last day of limitation, you should be very, very careful that you are presenting the plaint before the correct court. Limitation and then court fee. Court fee in one or two aspects. Case law is necessary. Suppose when you are challenging a document to which your party is not a signatory, then Supreme Court said you can seek the cancellation on the basis of a notional value. And then there may be specific types of suits. Say an illiterate woman or even a blind person seeking the cancellation of a gift deed obtained by his own kith and kin. are instances of undue influence. Party may not tell you all the facts, but Article 6 Rule 4 CPC requires that all those facts are properly pleaded in the plaint. Article 6 Rule 4 CPC says, whenever you are pleading, your plaint is based on, in all cases in which the party pleading relies on any misrepresentation, fraud, breach of trust, willful default, or undue influence, and in all other cases in which particulars may be necessary, beyond such as are exemplified in the forms aforesaid, particulars with the dates and items, if necessary, shall be stated in the pleading. This is very important, and this is mostly ignored by parties. They may not realize the importance of revealing all these things, but you should ask them. You are saying undue influence. Defendant obtained a document by undue influence. What was exactly the relationship between you? Are you related by blood? Are you friends? Are you having a relationship in which the other side has an upper hand? Are you working under him? What exactly is the relationship through which you are trying to establish that there was undue influence or fraud or misrepresentation or whatever it is? Or the parties were in fiduciary capacity. For this, foundation has to be laid in the pleadings. Without that, we may not be able to lead evidence. And then there may be suits based on the will of a person. So and so executed a will in my favor. He died, the will came into operation, and I am entitled to the properties under it. Now, whenever somebody is propounding the will, it is for him to plead and prove that it was voluntarily executed by the person, that it was properly attested. What is the definition of attested under the Succession Act? What is the definition of attested under the Transfer of Property Act? And then ultimately the party who propounds the will has to remove the suspicious circumstances. Therefore, you have to say, so and so is my grandfather. He had nobody else. I asked him to stay in my house. I looked after him. When he fell sick, I took him to hospital. And ultimately, because of our close relationship and because of all this, he had executed a will. For this purpose, you have to read at least some judgments relating to the proof of a will, the circumstances under which a person executes a will and which are accepted by courts, and what is meant by this removing of suspicious circumstances. Suppose somebody is in a hospital, he dies on, say, 15th November, the will is dated 14th November. Then you have to explain it in the pleadings as to why he has suddenly executed a will on 14th. Whether he told somebody, "Oh, my health is not good, I am going to execute." There are various instances where the suspicious circumstances are not removed by the propounder properly. Therefore, keeping in view the nature of suit which you are drafting, you have to take instructions, you have to decide whether a notice is necessary, and then you have to draft the pleadings keeping in view the properly explained limitation and also paying correct court fee. Because if the court fee is not paid intentionally, then the other side may come and say it's a fit case for rejection of plaint. So this is as far as plaint is concerned. And once again, I am bringing to your notice that Evidence Act is something like a key. Adoka Tadam. It will open our minds as to what we should do in a particular type of case. What type of evidence is admissible or relevant? How do you prove a contemporaneous arrangement which is not depicted in a document executed in between the parties? What are the exceptions to 91? Suppose the party comes and says, sir, this is the document, but at the same time there was such an arrangement. So, unless you have grip over the Evidence Act, you will not have an idea as to the nature of evidence that will be ultimately required, and the nature of that evidence should have a basis in the plea. What evidence is admissible when you are talking of relationship? Somebody may come and deny that relationship also. How do you prove it? Therefore, while taking instructions, you should ask the party as to what type of evidence is available with him on a particular fact. And I ask you to repeatedly go through all the illustrations in the Evidence Act. They cover a number of situations which we come across in several suits and cases which come before, which are handled by us. Cruelty. If you look at the illustrations under section 14, then you will see that there is a illustration with regard to cruelty also, which is regularly pleaded in the Marriage Act cases. The question is whether A has been guilty of cruelty towards B, his wife. Expressions of their feelings towards each other shortly before or after the alleged cruelty are relevant facts. This is my illustration K under section 14. 14 has got number of illustrations. All these illustrations contain a fact situation or model facts. Where do they fit in when you draft the pleadings? That is what you should do. Section 32 doesn't speak only of a dying declaration in a criminal case. It has got 8 clauses. Some of them are applicable to civil cases also. As I said, 13A, 32 clause 7, 48, they are connected. And suppose you are seeking damages. Section 55 says in civil cases, the fact that the character of any person is such as to affect the amount of damages which he had to receive is irrelevant. Therefore, when amount of damages comes, section 55 has to be borne in mind. Unless you gradually acquire mastery over Evidence Act, or where to look with regard to a particular type of suit or a particular type of issue that comes forth, that is to be decided in a suit. then it will be difficult for you to draft the pleadings in a proper manner. Now, this is what I have said about basically from the side of the plaintiff. There may be certain types of suits which do not regularly come. The suit may be based on promissory estoppel. Promissory estoppel is not only a rule of evidence, but it gives rise to substantive rights. So you should know what exactly is promissory estoppel and in what circumstances it gives rise to a substantive right which can be asserted in a pleading. I have seen number of parties who think that some of the documents with them are not, they themselves decide that they are not important. That's why I said we should collect everything from the party, whether oral or document. So this is one aspect. And we have got more number of cases today in family courts, particularly in cities. Though the episode starts from the time of proposals between them. There will be several instances of disagreement between them. The disagreement may blow up into something more. Please remember, the question of cruelty will be decided on the basis of the peculiar facts in each case. That's what the case law says. Therefore, whenever you are crafting a pleading in a matrimonial case, it is better if the party is literate to ask him to write down chronologically what happened between them. So that you can utilize them properly in the pleading. If you take only oral instructions, he may miss something or you may miss something. Therefore, it is always better if the party is literate in a family dispute, you ask the party to write down the actual dispute between them, several episodes that have occurred between them, several types of messages that have been exchanged between them, any emails, any notices, any incident. Nowadays, this is very important because ultimately you may be blamed. Family court issues are very, very contentious. Sometimes you may be able to inform the parties that what you said may not amount to cruelty. And if they have already filed a case under 498A, what are the allegations in the FIR given by them? You should not write anything repugnant to what is stated in the FIR when you are drafting a petition for divorce or the written statement. Therefore, family court issues, they stand apart as far as taking instructions, and every single incident in between the spouses should be noted, at least at the time of instructions, and whatever is necessary to be stated in the pleadings according to the grounds of divorce or whatever it is, or the petition for restitution of family rights. At least you should know what happened between them right from the time of proposal for marriage, demand for the etc. Whether there were any loans were incurred, whether one of the spouses has taken a loan and purchased something for the other side, for the other spouse, all these things, they should be within the knowledge of the advocate. And we come to written statement. Return statement sometimes may be in the form of a counterclaim also are set up. But apart from that, when you are filing a counterclaim, it is almost a plaint. But ordinarily in the return statement, there must be specific denial of the facts which you are not admitting. If there is no specific denial, they are deemed to have been admitted. That is Order 8, Rule 5. There have been instances where either by way of oversight or not noticing a fact which is already pleaded, then proper denial is not there. Order 8, Rule 3. It shall not be sufficient for a defendant in his return statement to deny generally the grounds alleged by the plaintiff, but the defendant must deal specifically with each allegation of fact of which he does not admit the truth except damages. Therefore, the denial must be specific, and then what is an evasive denial? What is a specific denial is clearly stated in Order 8, Rule 4 and 5. Where the defendant has not filed a pleading, it shall be liable for the court to pronounce judgment. That is Order 8, Rule 5. There are two ways of drafting a return statement, which I have come across. One sentence, positive sentence. Defendant humbly submits that he is a resident of Guntur. The second sentence, the allegation in the claim that defendant is residing in Chirala is false. Again, the defendant humbly submits that he has been in Guntur working in so and so company for the last 20 years. Stop. Very next sentence, the allegation by the plaintiff that I am working in Hyderabad is false. No, this will not be so convenient for the court to look at. Whenever you want to deny something specific, you complete the denial and then come to what you want to actually submit. So that at the time of judgment, it will be easy. Otherwise, the court will have to search as to what fact is actually denied and what fact is not actually. I heard arguments in a case, and after going through the pleadings, I found that there is a pleading with regard to payment of 15 lakhs by the defendant to the plaintiff, which did not come up for consideration at any point of time. And I reopened the evidence and asked the party, yes, sir, 15 lakhs is received. Therefore, out of 30 lakhs that is sought in the suit, 15 lakhs is already. Why this occurred? Because such an important fact is not projected properly while drafting the returns or the claim. So whenever there are important facts which you think the court should know, then you allot a paragraph for that, so that when you argue, you can directly go to, sir, this is the important paragraph on which my case is rested. I have narrated all the important facts in this. Then another thing is, go for simple sentences. X has got 4 sons. Plaintiff D1, D2, D3 are his sons. Plaintiff's father and father of D1 to D3 are the same. This is an indirect way of saying this. So, whatever you want to project, you project with simple sentences. And it should be effective English. English is a language in which these words used will have a very good effect if properly used. You can convey a lot. I'm not saying that it is not possible in Telugu, but in English also, the selection of words is very, very important. Sometimes there may be a technical lacuna in the plane which you want to project. Say, let us say the suit is barred by limitation. There is no cause of action. The plaintiff has intentionally played both feet under a wrong provision of law and has paid less both feet. Or this particular suit is barred by a particular law. Then that is very, very important. That also you should know. Somebody brings a plane. You should verify whether such a relief is barred and whether such a suit is barred in a civil court, and whether there is another tribunal which has to deal with it. And assuming that there is another tribunal which can take up that case, what are the circumstances under which a plaintiff lies? Suppose the other side does not follow any of the procedures laid down under that particular enactment and does something in contravention of the enactment, then the civil suit may lie. Therefore, when you are answering a plaint, when you are filing a written statement, apart from the instructions that you take from your client with regard to all the facts that have been pleaded, you also look at the technical lacuna that may be there in the plaint. Also see whether such a suit is barred by any other act or by it is barred by limitation. That is something which falls within the realm of the duty of the advocate. Party doesn't know. Party simply brings you the summons and the plaint and asks you to file a wakalat and a written statement. That again involves a proper investigation into the plaintiff, proper understanding of the plaintiff issues. And substantive law you cannot ignore. Knowledge of substantive law you cannot ignore while drafting a plaint. Let us say an unmarried daughter comes and says, "Sir, please file a suit against my father for my marriage expenses." Is it covered under 125 CRPC? Is it covered under Domestic Violence Act? Where is it covered? Where this right of asking the father to pay the expenses for the marriage, that is with regard, that is in the Hindu Adoptions and Maintenance Act, where the definition says that it includes expense of marriage. Therefore, this type of knowledge is very much required And whenever you are preparing the pleadings, there should be a permanent note in your file. If possible, even the case law, particularly when you are crafting written statement. The enactment which covers that case, the substantive law which covers that case, and the Evidence Act that covers it. It makes a lot of difference for you to draft the pleadings. And case law, I will tell you an example. There is a Osmania University case decided by Justice Janamana Rao, 39-1. There was a plea of adverse question by one of the parties. But there was a break in the period of adverse possession. And that break was not actually a legal way of taking back possession. But still the court said it constitutes a break in adverse possession. So certain legal principles which are there in some judgments you should be aware of, because if you are facing a suit for declaration that the plaintiff has perfected his title by adverse possession, how should you counter it? You are having title, but the other side says, for more than 12 years I have been uninterrupted possession in that. Is there something which you can make out, by which you can make out that there was no continuous possession for 12 years? Therefore, whenever you come across a particular type of suit, whenever you are drafting, you should go through the substantive. Easements, you should go through this. What type of easement you are pleading? Is it a grant? Is it a prescription, or is it a necessity? I very well remember drafting a plaint in my office, our office, when I was an advocate. Only after going through the law of easements, then only we drafted it. If you file 10 cases with all diligence, then you will realize that conducting civil cases is not so difficult as this. But if you miss certain things while drafting pleadings, if you don't take proper instructions from your party, then ultimately you have to file additional written statement or amendment of claim. Then a lot of practical problem comes, particularly after the CP season. So 3 things. One is taking instructions from a competent person, whether it's a plaintiff or defendant. Understanding of the substantive law covering that particular type of suit. And then the relevant provisions of the Evidence Act, which give us a key which can open the case of the plaintiff before the court in a proper time. What type of evidence is relevant? Only relevant evidence you can place before the court. Section 5 of the Evidence Act says evidence that is relevant here and after relevant of no others. Therefore, these are some of the basics which I want to place before you. And then commercial courts, if it is a suit under Commercial Courts Act, you have to draft the pleadings as per the provisions of the Commercial Courts. And if it's a suit for partition, you have to specify the actual share the plaintiff is seeking. And what are the consequential reliefs you have to pay? What are the distinct reliefs you have to pay? You have to see. What are the separate reliefs you have to see? Suppose you seek a declaration, but you don't seek a consequential relief, then of no use. This is a continuous process of learning, whereunder you increase your familiarity with the Where Act. You read judgments which are quite essential to drafting. There used to be one suit of 1956 in Mongol subcourt when I entered practice in 1983. The written statement was got drafted after much discussion, and it was drafted by an eminent civil advocate at Hyderabad. And some of the pleas, the circumstances which were explained, it was a case of allegations by a widow. And under what circumstances she made those allegations, the narration is very beautiful. Similarly, in the case of adoption, prior to 1956, a plea was taken that the widow had asked the agnates their consent for adoption, and they did not give any reply. And that particular pleading came to the rescue of the adopted son, the Privy Council, that has gone up to Privy Council. Therefore, whatever may be the manner in which suits are going on, the manner in which litigation is being conducted, whatever it is, the knowledge of the advocate while drafting pleadings, the knowledge of the advocate with regard to substantive law and evidence act, they are very good. And sometimes there may be presumptions under other act, say 118 NI Act. You should also know those presumptions. So this is all what all I wanted to say, and now I think somebody who is anchoring the program, they may say that questions are welcome. Yes. Any questions on the topic? Whoever is coordinating the program, I request you to inform the participants that questions can be asked. Yes, please. Am I audible?
Yes, sir. Is it audible?
Yes, please. Anybody wants to ask any questions? Please unmute and ask questions. Yes. Only video is coming. Audio is not coming in return. Video is coming, audio is not coming. From Raidu to everyone without audio. ఎవరో మెసేజ్ పెట్టారు ఆడియో రావట్లేదు. So any questions from the participants?
Hello.
Yes.
Sir, I want the based on natural calamity contract clause. The natural calamity contract clause is available in the United Nations. So I raised in the United Nations. Boxing Day 2004 came as my planned date, 26th December 2004. So the main thing is, if anybody gave natural calamity warning for Sri Lanka, USA means that person is a owner. So, as per my planned date, tsunami came. So, earthquake and tsunami in Sri Lanka and Alaska, USA earthquake in that event. So that I am earth owner. So all the civil cases filed. So already I gave my so many different calls and I could register. So all the civil cases filed. So property now the constitutional remodeling is required. So text message I texted.
Your pronunciation is not clear to me. Your voice is clear to me.
Now I am in Tamil Nadu, sir. Tamil
Hello?
Nadu, Tirupuri. Nothing. Natural calamity contract clause is available in the United Nations. In the United Nations, I registered. Boxing Day tsunami came, you have to remember, it is in 2004. When I was in small age itself, I raised an UN through NASA's virtual simulation technology of NASA. So I fixed the Boxing Day tsunami date. In the particular date, tsunami came. So I am the earth owner based on natural calamity contract clause. So if I am earth owner, means all the three cases void. In Bangalore High Court, there is one standing order is available. If any civil case becomes void, automatically related to the criminal case also void. This standing order. So in the Rajiv Gandhi assassination case also appeared. So in that one, the committee is a civil case. So that civil case is void. So that the criminal case also void. So these 3 days I sent to the authorities. So my friend gave this meeting ID and other things. So I want to convey my messages to you so that I participate in this meeting.
This particular session is on pleadings and drafting.
Yeah, drafting and pleading, but CPC is not 26th December 2004 tsunami came. On the day I owned the earth. I own the earth means there is no CPC, property law, monopoly government in the world. So 26th December 2004 all belongs to me based on natural calamity contract clause. So there is no then going for pleadings and others. So for that I want to convey the message.
I'm not able to understand your pronunciation, sir. It's
Sir,
not-
26 December 2004 tsunami came on the day I own the earth. So if I own the earth means all the property belongs to me. So that all the civil case is void. All the civil case is void means company law, all the company is monopoly means all the company belongs to me. The property law, there is no property law. So constitutional remodeling is required means all other laws we have to modify. So there is another one message I want to tell you. Perivalan and team, the Rajiv Gandhi assassination case, that person took Somoto. Somoto, on the time from the NASA, they told me Somoto means CBI case only Somoto can be taken, and it should be taken in High Court and it should be forwarded to Supreme Court. So, Somoto what
Our pronunciation is not clear and we are unable to understand. You have referred to Rajiv Gandhi assassination case. It is not pertinent to today's topic.
Hello, sir. Good evening, sir.
Okay.
Sir, one person, A person, his wife has been sold a property to X person, and his husband, B person, is asking, has been written a caution deposit a flat own like a flat owners and deposit 50,000 with a X person. Is it can be filed in the civil case, sir? With
Not
harassment they have been.
going to answer what is a civil case and what is a criminal case. We are only on the point of drafting pleadings whenever a certain set of facts come to.
Okay.
You have to write down the facts and then formulate whether a civil suit will apply.
On that case, I can file a case on husband, sir, without any caution. He has been
That's what I'm
written
saying.
in the agreement.
So, details have to be sufficient to arrive at a conclusion.
Can I ask in Telugu, sir?
Alright, Telugu alright.
సార్ భార్య మీద ఫ్లాట్ ఓనర్ సార్ అట్లయితే భర్త కాషన్ డిపాజిట్ అని ఎక్సెస్ అమౌంట్ ఇప్పించిండు విత్ ఏ ఫ్లాట్ ఓనర్. కాబట్టి ఓనర్ ఒకరైతే వాళ్ళ భర్త ఇన్వాల్వ్ అయ్యి 100 రూపీస్ బాండ్ పేపర్ మీద రాపించుకొని కాషన్ డిపాజిట్ అంటే ఫర్ ద మల్టిపుల్ పర్పస్ అన్నట్టు బలవంతంగా హారాస్మెంట్ వేసేసి ఇప్పించుకున్నాడు. అమ్మినాక ఆఫ్టర్ సెల్లింగ్ ద ఫ్లాట్ సార్ భార్య మీద ఉన్నది.
ఏదో కొంత అమౌంట్ ని అన్యాయంగా నుంచి తీసుకున్నారు మోసం చేసి.
అవును సార్, అదే హారాస్మెంట్ చేసి
అడగచ్చు. విత్ ఇన్ ది ఎప్పుడైతే అది తెలిసిందో అప్పటి నుంచి 3 years లోపల అడగచ్చు.
మనీ సూట్ వేసుకోవచ్చా సార్, లేకుంటే సివిల్ కేసు ఏదైనా వేసుకోవచ్చా?
అంతే, వాళ్ళకి కావాల్సిందే డబ్బులే కదా.
అవును సార్, అవును సార్.
ఈ డబ్బులు నా దగ్గర నుంచి ఈ అక్రమమైన పద్ధతిలో నా దగ్గర నుంచి తీసుకున్నారు, దాన్ని వెనక్కి ఇవ్వండి విత్ ఇంట్రెస్ట్.
ఓకే ఓకే సార్, థ్యాంక్ యూ సార్.
Yes.
Hello, sir.
Yes, please.
Sir, in drafting, shall we consider the ethical considerations, sir, in presenting the case? Presenting our plaint?
Sometimes the conduct of a party is very important.
Sir.
As I told you, suppose it is the question of true in the will. The conduct of the person in whose favor the will is there is very important. And similarly, in between spouses also these considerations will come. That's why I said section 7 of the Evidence Act. It is very comprehensive. It gives you an idea as to what ultimately becomes relevant.
Sir.
Facts which are the occasion, cause or effect. Suppose in these three, the ethical issues also come and nothing wrong. Immediate or otherwise of relevant facts or facts in issue or which constitute the state of things under which they happen or which afforded an opportunity for the occurrence or transaction. So depending on the nature of the dispute, you can plead nothing wrong.
Okay, sir. Sir, one more.
I'll tell you an example.
Sir, please, sir.
I decided a suit in which a person who had no children executed a will in favor of his relative's daughter or son. I don't remember exactly. Then other side came up with another will saying that this person executed this will and not that will. And he had actually fostered one guard from his relative's side. And then I had to decide which will is true. Apart from other things, I saw one peculiar circumstance in the suit. The person who wrote a will, he had disputes with his wife, and then without taking divorce, he asked her to live apart and gave some 4 or 5 acres of land for her maintenance without any litigation. After 30 years, the wife wanted to come and live with him.